All right, I'm ready on Yerger.
Ready, Your Honor.
Mr. Yerger, please start your camera, sir.
Good morning.
Please start your camera, sir.
Please do what? Oh, I'm sorry.
This is case number 234521501, the people of the state of Michigan versus Carl Henry Yerger. The defendant is charged with 1 count of guns reckless use. Today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 8350.
Good morning, Your Honor. Good morning to your staff. Robert Gross, P82012. I am standing in place of counsel of record attorney Caitlin Crapo, and I'm appearing by Zoom this morning. Mr. Yeager, can you please state your name for the record?
My name is Carl Henry Yerger III.
Thank you. Today is the date set for a pretrial conference. Mr. Gross, how are we proceeding?
Your Honor, at this time, I think we need to just set another pretrial date. We currently have discovery, but we are lacking body cam, which we've been seeking. So we would just ask for another pretrial date.
The court is going to continue a not guilty plea on behalf of Mr. Yerger and set the matter for a final pretrial conference. The court will set a final pretrial conference for February the 23rd, if that's a good date for you, counsel.
Let me just consult my calendar and Attorney Crapo's. What time would that be, Your Honor?
9 o'clock.
That works for us.
Court sets the matter for February 23rd at 9 a.m. Bond will continue, but I'm going to ask a question. The matter is scheduled at 8:35. That means at the last court hearing, your client failed to appear. And instead of issuing a capias, I adjourned it and set it at 8:35. I'm not sure what happened, but everybody need to write down the court dates, because at the next time he misses, I'm going to capias him, issue a warrant for his arrest.
Understood, Your Honor, and we appreciate this court and this court's time, and we'll make sure that he'll be here punctually at 9.
May I speak?
Counsel, your client wants to speak.
I think
was on a Zoom meeting. Hello? I was told that that I didn't appear.
Absolutely. Have a good day.
I was at a Zoom meeting here, and they had a bomb threat, to my understanding, and they set another date.
Mr. Flanagan, can you look up Mr. Yerger's case? Why is he scheduled at 8:35? Was he scheduled at 8:35 on the day of the bomb threat?
I was.
Sir, I'm talking to my clerk.
Oh, I'm sorry, ma'am.
Thank you. Hold on.
No, on October 26th, he was scheduled at 8:30.
October 26th, that was the day of the bomb threat?
That was the day he last scheduled to appear. Not sure if that was the day of the bomb threat.
Tell you the day of the bomb threat. Okay, so the day of the bomb threat was October 26th. And then what was his next scheduled court date?
20.
Sir, I'm talking to my clerk, please.
I apologize.
Okay, Mr.
It was
Flanagan.
on, oh, yes, Your Honor. It was scheduled on November 22nd for 8:35, and it was removed from the calendar and placed on today for 8:35.
So why was it put for 8:35?
On October 26th, it says he failed to appear.
Oh, no, that was the day of the bomb threat.
Yeah.
So, okay. All right, so let's remove that. If you could go back and change it, because when I'm looking at the history, I'm gonna see 8:35. So if we could change his time for at least even today for 8:30. Because if I'm
Okay.
looking at the history, I'm gonna see 8:35.
Okay.
All right. Then we apologize for that error. It should have been on for 8:30. For 8:30. All right, then we're all set until February 23rd at 9:00 a.m. Anything further?
Nothing at this
Judge,
time. No, thank you.
Ms.
I'm sorry.
Ritter?
The people did send over the digital discovery to Ms. Crapo.
All right. Then we are set. Everyone have a great day. Stay safe. Happy New Year.
Thank you. You as well.
All right, you're welcome.
Thank you, Your Honor, and stay safe and have a successful new year.
Thank you. You as well, sir. All right, Mr. Basant, I'm ready.
I'm here,
Let's do Banbury first, I guess. All right. I need Ms. Caldwell to start your video, please. Okay, this is case number 214424802, the people of the state of Michigan versus Asia Banbury. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I also have the complainant witness present via Zoom this morning. Ms. Caldwell, can you unmute yourself and state your name for the record?
Bianca Caldwell.
and good morning, Your Honor. Attorney Kevin Basant, P71061, on behalf of Ms. Asia Banbury, who's also present by Zoom video, Your Honor. Ms. Banbury, can you state your name for the record?
Asia Banbury.
Today is the date set for pretrial conference. Mr. Basant, how are we proceeding?
Judge, I would like to set this matter for one final pretrial conference to get discovery in this particular case, so I can review that with my client and prepare appropriately, Your Honor.
This is at 8:25. Discovery should have been ordered. It wasn't.
Well,
Oh, no, it probably wasn't because no, it wasn't. It wasn't. All right. It wasn't ordered. Okay, the court is going to continue a not guilty plea on behalf of Ms. Banbury, and I will set the matter for a final pretrial conference. Friday, March 15th, if that's a good day for you, Mr. Basant. Mr. Basant?
oh, I'm sorry, I was on mute. I said that date works for me. March 15th is fine.
Oh, okay. All right. Court sets a final pretrial March 15th at 9:00. And then discovery should be submitted to the defense by February 15th. And then bond will continue with no contact with Ms. Caldwell. Ms. Caldwell, you have appeared today, and therefore your appearance is not required on March 15th. However, ma'am, you may appear on on March 15th if you want to, but you're not required to. If you don't appear, then you should contact the prosecutor's office to find out when the next court date is and whether your appearance is required. Anything further with respect to Ms. Banbury?
No, thank you.
Thank you, Judge.
All right, then ladies, you're all set. Have a great day. Stay safe and Happy New Year to you.
Thank you. Same to you.
Thank you. All right, I'm ready on Deshawn. This is case number 174577101, the people of the state of Michigan versus Gabrielle Lynn Deshawn. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial. Whoops. Today, I didn't mean to do that. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And good morning again, Your Honor. Attorney Kevin Bryant, P71061, on behalf of Mr. Gabriel Deshawn, who's also present by Zoom video.
Mr.
Deshawn, can you
Deshawn,
state your name for the record?
unmute your device.
I'm sorry. Good morning, Your Honor. My name is Gabriel Deshawn.
And is your middle name Lynn?
Yes, it is.
Thank you. All right, today is the day set for pretrial conference, but before I say how you want to proceed, there's an unidentified, oh, it's okay. I'm gonna identify this device. Can the person who's identified as Red Baby's iPad please unmute and tell the court your name?
Alexander Jones.
Thank you. Mr. Jones, I'm gonna send you to a breakout room. And the lawyers will be in to speak with you. Please accept to join the breakout room and then wait for a lawyer to come into the breakout room to speak with you.
Thank you.
All right. Okay. With respect to Mr. Deshawn, today is the date set for pretrial conference. Mr. Bryant, how do you wish to proceed?
Just today is the date and time scheduled for pretrial conference. We did receive discovery in this matter, but it's my understanding, Judge, I may be incorrect, but I thought the complainants had to be present in court today. I'm not sure that they are or not.
Ms. Ritter?
So today is the second scheduling of the pretrial conference, and the court did require the complainant witness, Mr. Richard Oliver, to be present. I don't see Mr. Richard Oliver in the waiting room, and I believe all the unidentified devices have been identified at this point, Judge. So the people have no explanation as to why the complainant witness is not present, and at this time we will not be able to move forward.
Mr. Bryant?
Defense counsel will move forward dismissal, Your Honor.
Today is a date set for pretrial conference. It is at least the second scheduling of the pretrial conference. The complaining witness was required to appear. He has failed to appear. The people have no explanation for that failure, and they are unable to proceed. The court is going to grant defense counsel's motion, and the matter is dismissed without prejudice. Mr. Bryant, if you could submit an order to my clerk, I will sign it, and then Mr. Deshawn, your lawyer, will get you a copy of that order for your records, okay?
Thank you very much, Your Honor.
You're welcome.
Thank you, Judge. I will
Anything
submit that to the
further?
court today. That's in front of defense counsel. Thank you, Your Honor.
All right. Then have a great day. Stay safe and Happy New Year.
You as
too,
well.
Your Honor.
Thank you. Mr. Johnson,
Good morning, Judge.
good morning. If you could start your video. You're here on Ashwood.
Yes, Your Honor. It won't let me.
Oh, it sure won't, because I had to let that other device in. All right. You should be able to do it now.
Okay.
Okay, yes. All right, your client is ready here. Did you need to speak with your client or are you ready to proceed?
Ready to proceed, Your Honor.
Okay. All right, then this is case number 224522702. Oh, man. Mr. Flanagan, remind me to go back to the Banbury case and ask you a question. All right.
Okay.
So this is case number 224522702. The people of the state of Michigan versus Madison Ashwood. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And good morning, Mayor. Please, Honorable Court, Vassal Johnson II, P72130 on behalf of Ms. Ashwood, present on Zoom.
Ms. Ashwood, please unmute and state your name.
Madison and Ashwood.
Thank you. Today is the date set for pretrial conference. Wait, today's the date set for final pretrial conference. Mr. Johnson, how are we proceeding?
Yes, Your Honor. If the complainant isn't here, I believe she was required to be here for the final pretrial. I would move for dismissal. Also, the sister counsel was to provide discovery by December 5. All I have is paper, and in the police reports it reflects in-car, body cam, 911. I don't have any of that. So I would move for dismissal based on those grounds at this point.
Ms. Ritter.
Your Honor, it looks like the complainant witness appeared on October 20th of 2023, and I don't have any notes indicating that the complainant witness was required for today's final pretrial. So I asked the court to actually deny defense counsel's motion regarding that. With respect to the body-worn camera, Judge, it looks like there have been several attempts to get the video discovery, if any is still existing, and I sent emails out to, it looks like a couple of supervisors at Detroit Police Department. At this time, Judge, I have not received a response, so the people can attempt to try again, but the remedy for not having a digital discovery by the final pretrial conference wouldn't be a dismissal, so I'm going to ask the court to deny defense counsel's motion.
Today is the day set for final pretrial conference with respect to the motion to dismiss based on the complaining witness failure to appear. The complainant was not required to appear today. If they previously appeared at the pretrial conference, the court is going to deny the request based on that. If the complainant had been required to appear, the case should have been on the court's docket for 906. A 6 always denotes that a witness was required to appear. Secondly, with respect to the discovery, I'm not going to dismiss it at this particular time for failure to produce the digital discovery, but you know, tell the supervisors it's Judge Bryant's case, and they better get that discovery to get it to you so that you could get it to Mr. Johnson. And then, you know, of course, the court would have to do an assessment of what the digital discovery is and whether it will require dismissal, because it's not as simple as just saying it would be excluded evidence. Of course, if the evidence was to the benefit of the people, then it would be excluded evidence. But if evidence is to the benefit of the defense, then that might warrant a dismissal, because now the defense doesn't have a proper defense because of the failure to produce discovery. So I'm going to set another final pretrial conference, but at that final pretrial conference, we need one of two things. We need the discovery to be produced, to have been produced, or we need some official notification. And you all know when I say official, I do mean official. That means it has to be on Detroit Police or state police or whatever police agency. It must be on their official letterhead indicating that the discovery that you have requested does not exist, and why it doesn't exist. So if the police report says that there's a body cam and then there's no body cam, then there needs to be something saying why there's no body cam. You know, it's destroyed after a year. It's whatever the case may be. That's what we'll need. So let's set up final pretrial conference. Mr. Johnson, does March the 15th work for you?
Yes, Your Honor.
I'm going to adjourn the final pretrial conference to March 5th.
Wait, 15th or 5th?
I apologize, 15th. I meant 15th.
Okay.
I meant 15th. I'm sorry.
It's okay.
And that's at 9 o'clock. The complainant is not required to appear. They've already appeared in October, and I usually don't make them appear again unless about a year has passed. And then I'll say that it's kind of remote in time. So, but the discovery must be produced or some type of indication as to the lack of that discovery, the fact that it does not exist. All right, anything further?
No, thank you, Your Honor.
No, Your Honor, thank you.
All right, then we're all set until March 15th at 9 o'clock a.m. Everyone have a great day. Stay safe and Happy New Year to you.
Happy New Year. Thank you, Judge.
You're welcome. All right, Ms. Hall, are you ready on Brooks?
I am not ready on Brooks. I am ready on Eccles.
I want to be ready on Brooks and Brown. Can somebody be ready on
Okay,
Brooks and Brown? Because I have two complaining witnesses.
Yes, give me 1 second, please.
Okay, Ms. Ritter, go in and talk to the witness on Brown.
Yes, sir.
All right.
Your Honor,
Yes.
you wanted me to remind you about Danbury?
Okay, yes. I set that date. Hold on, let me turn on my camera. I'm sorry. I set a date, but what's the status of 01? What's the status of defendant 1?
Defendant number 1 is closed. Let me make sure it's the right one.
Oh, okay. It could be. It's a 21 case. See if defendant 1 is already adjudicated.
Yeah, it was closed March the 3rd, 2022.
Okay, that's fine. Okay, thanks.
You're welcome.
Mhm. Ms. Ritter?
Yes, Judge.
Wasn't Joy T-Mobile your witness?
She had to log on and come back.
Okay.
Your Honor, I still have not received a response from Ms. Stevenson. Should I just pop into the breakout room with her?
Yeah, yeah. She don't look at her phone. One day it's gonna not. Ms. Ritter, did you need to speak with her?
I did, Judge.
Ma'am, please accept to rejoin the breakout room.
Your Honor.
Did you call me, Ms. Hall?
I did. We are ready on Brooks, and she is going to come out for Brown if we can do Brooks first.
Okay, as soon as Ms. Ritter comes back.
Thank you.
Mr. Flanagan,
Yes, Your Honor.
I've stepped away from my computer, so when Ms. Ritter comes back, just either somebody call out my name or text me. I'm stepping away from the computer.
Okay.
All right, thanks.
Welcome.
Hello.
All right, I'm ready on Brooks. I need Ms. Brooks to start your video, not unmute. I need you to start your video. Hmm. All right, this is case number 234442101, the people of the state of Michigan versus Bonita Devon Brooks. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I have the complainant when it's present via Zoom this morning. Ms. Watkins, unmute yourself and just state your name for the court.
Good morning, Gwendolyn Jean Watkins.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Bonita Brooks. Ms. Brooks, ma'am, please unmute and say your full name.
Bonita Devon Brooks.
Today is the date set for final pretrial conference. Ms. Stevenson, how are we proceeding?
Thank you, Your Honor. Ms. Brooks will continue her plea of not guilty, and we ask that the matter continue as scheduled to trial on January 9th. But Ms. Brooks and I have had the opportunity to discuss this matter She wishes a waiver of rights incident to jury trial and asks that the matter be heard by this court.
That might not be possible. Mr. Flanagan, can somebody tell me about Merida? Did I already do something different with Merida? Oh no, Merida is on the docket. Is Merida present?
I haven't talked to Mr. Merida today yet, Your Honor.
He's not in person either, Your Honor.
Well, now I gotta recall this. Mr. Merida was scheduled at 9:12, and while he is late, I can't tell you whether we can have a bench trial on January 9th. And Mr. Merida's case is first in priority. And I'm not gonna yeah, so I can't do it. Do we have a phone number for Mr. Merida?
I haven't been able to reach Mr. Merida, Your Honor.
Mr. Flanagan, can you send me the docket for January 11th?
Yes, Your Honor.
Oh, no. This is a bench. I can't do it January 11th. Can you send me the docket for Are all three of my bench trials still on the docket for Monday?
Yes.
All three of them are?
Yes.
Which one is probably gonna go? Mr. Upshaw's case?
From my understanding, Judge, Mr. Upshaw did indicate that that's a go. I can tell the court right now on the people's end, Malcolm will not be a go.
Murillo is a go, Judge.
Okay. What's Mr. Merida charged with?
Malicious destruction of the building at the jail. Is that right, Ms. Ritter?
Correct.
All right. Okay, with respect to Ms. Brooks, the court will continue a not guilty plea. Continue the matter to trial. With respect to the trial, Ms. Brooks, your lawyer has indicated that you want to give up your right to a jury trial and have the matter heard by the court instead. Is that what you want to do? Please unmute yourself.
Yes, Your Honor.
Ma'am, do you understand that if I accept a waiver from you today, that your matter will be heard by me? I will be the only decision maker. Do you understand that?
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to give up your right to a jury trial and have the matter heard by the court?
No, Your Honor.
Any objection from the people?
No objection, Judge.
Having no objection from the people, finding that this waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. And the matter will proceed to waiver trial on January the 9th at 10:30 a.m. Anything further?
No, Judge, nothing from the people.
Nothing on behalf of Ms. Brooks. Thank you, Your Honor.
All right, then, ladies, you're all set. We'll see you Tuesday at 10:30 at courtroom 339. Have a great day. Stay safe. Happy New Year.
Happy New Year. Today's my birthday. I made it.
I mean, who is saying that? Who would say that on my Zoom, on the court Zoom? Can somebody explain that to me? Nobody has an explanation.
Oh, I'm sorry.
That's so disrespectful and rude. I can't imagine. This is why we're going to get rid of Zoom court. It's not a casual place, right? It's a place of business. Ma'am, stop unmuting yourself. Stop unmuting yourself. It just appears to me that with the court speaking about that, you would stop unmuting yourself. Ms. Brooks, have a great day and stay safe. Can Ms. Flemings please start your video camera?
In itself. There it is. My microphone keeps muting.
Stop. 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 Stop.
Ms. Flemings, please remain muted. Just remain muted until the court allows you to mute.
But I've said that no less than 4 times. No less than 4 times I have said to stop unmuting yourself. No less than 4 times. No less. All right. I am ready on Brown. I'm ready on Brown. I am ready on Brown. What I know for sure is that I speak English. Miss Ritter speaks English. We both speak the same language. When Miss Ritter said, stop unmuting, it was the same language that I was speaking when I said, stop unmuting. And all of a sudden, Miss Flemings has stopped unmuting. Let me say this to everybody, news flash. This is my courtroom. And when I speak, that's what is the word of the day. So I don't know why you decided you need to listen to Miss Ritter, but let's just be clear. Ma'am, stop making all those faces. Stop making all those faces. Miss Ritter, I'm gonna let you go back to the breakout room with your witness because we're not gonna proceed today like this, and she's gonna stop.
Yes, Judge.
She's going to stop. Sir, have a seat. We'll be with you shortly.
Go now, Judge.
Yes, please.
Thank you.
Should I wait or can I pop back in the breakout room or?
No, just wait, Miss Stevenson. We can ready to do the case.
Okay.
Can the person that I just let in please unmute yourself and tell the court your name? Tell the court your name. If you're speaking, we cannot hear you. Please log off and log back in. Mr. Barton.
Yes, Your Honor. Pardon.
I'm gonna go ahead and let you go. The person hasn't come. If we need you, Mr. Flanagan can call you. Does he have your phone number?
I'm not sure. Let me give that to you now if that's okay. Or how would you like me to do that? I could say it. No.
If you don't mind saying, I mean, we're live, but if you can put it in the chat or you could just say it.
I'll go ahead and say it live in case any clients want to call. I'm just joking. Your Honor. It's 313-288-8010. Again, that's 313-288-8010. Attorney Barton.
We know your name, Mr. Barton.
You let me finish my commercial, Judge. I was about to do a whole commercial. All right.
We know your name. All right.
Thank you, Your Honor. Good to see you guys. Y'all have a great one if I don't see you.
All right. Same to you, Mr. All right, let's try this one more time with the Samsung. Okay, well, I guess it's taking longer. I don't know what's taking so long. Well, they both talking at the same time. That's one thing. Go ahead, Ms. Stevenson. I'll bring you out. Ms. Stevenson, go ahead.
Okay. Wait a minute.
Please unmute and tell the court your name. Tell the court your name, please. Tell the court your name, please. Thank you for showing up. We're going to remove you from the courtroom. If you need to get in touch with the court, you can call 965-2295. 965-2295. 313-965-2295. Now, why is me? Please state your name for the court. Please unmute and state your name for the court.
Me?
No, ma'am. No, ma'am. No, ma'am. The person identified as Crowley, please unmute and state your name for the court. That's what I thought.
Reuben James Crowley Jr.
So, Mr. Crowley, why are you on two devices?
The other device is, the battery is going low. I'm using my phone. It's not allowing me to start my video.
I didn't ask you to start your video.
Oh, okay.
I'm going to send you this device to the breakout room with the other device.
Okay, and then I'll
Please
disconnect.
accept to join the breakout room. All right, Mr. Brown, you can step back up to the podium, sir. Ms. Flemings, you can start your video now. All right, this is case number 224495601, the People versus Antoine F. Brown. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I have the complainant witness present via Zoom this morning. Ms. Fleming, unmute yourself and just state your name for the court, please.
Joy Fleming.
Thank you.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Antoine Brown. Mr. Brown, sir, please tell the judge your full name.
Antoine F. Brown, Sr.
Thank you. Today is the day set for a final pretrial conference. Ms. Stevenson, how are we proceeding?
Thank you, Your Honor. Mr. Brown does continue his plea of not guilty. He asks that this matter be scheduled for trial. Mr. Brown and I have had a discussion about trial, and it's my understanding he wishes to waive his rights incident to jury trial and asks that the matter be heard by this court.
Mr. Brown, well, first, the court is going to continue a not guilty plea. On behalf of Mr. Brown, set the matter for trial. With respect to the trial, Mr. Brown, your lawyer has indicated, sir, that you want to give up your right to a jury trial and have the matter heard by me. Is that what you want to do?
Yes, ma'am.
Sir, do you understand that if I accept this waiver, that I will be the only decision maker, that you will not have a jury to hear the case? Do you understand?
Yes, ma'am.
Sir, has anyone threatened you in any way or promised you anything to get you to give up your right to a jury trial and have the case heard by me?
No, ma'am.
Any objection to the waiver on behalf of the people?
No objection, Your Honor.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. What did I do? Why did I put that there? Mr. Flanagan, on the week of January 29th, that Monday, the 29th, that's my jury trial day, right?
Yes, Your Honor.
All right, and then I have a jury trial on there, Hollis?
Yes, ma'am.
Okay. Is that the only one I have?
Yes.
Okay, thank you. All right, with respect to the waiver trial, the court is going to set the matter for Thursday, February the 29th. At 10:30 a.m. Anything further with respect to this matter? Do we need a final pretrial conference before that waiver trial date?
Judge, if it,
I'm sorry.
no, I was gonna say, if it pleases the court, the people don't need a final pretrial conference.
Ms. Stevenson?
Defense does not need a final pretrial conference, Your Honor.
All right, then we're all set until February 29th in person at 36 District Court, courtroom 339.
And Your Honor, before we leave, I do want the court to know that the people had an opportunity to speak with Ms. Flemings, and she does apologize to the court. She is having some technical difficulties this morning, and I did explain to her any future court dates that she should come in person.
Okay, because she looked like she's frozen now.
Yes, Judge.
Okay. All right, then we're all set. You can let her know. I don't know if she heard the court date. She looks frozen.
If she didn't, Judge, I will give Ms. Fleming a call this afternoon.
All right, then we're all set. Mr. Brown, we're all set. Have a great day. Stay safe. Happy New Year.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. I'm ready on Echols. And then somebody can go in and talk to Mr. Crowley. He was having difficulties. And then is Alexander Jones still in the?
He is.
Okay. All right. I'm ready on Echols. This is case number 234553901. The People versus Brittany Danielle Echols. Defendant is charged with two counts of OWI second. How is that possible, Ms. Ritter?
So, Your Honor, the way the complaint was typed out is kind of weird. So the count one is actually operating with a high BAC second offense notice. Count two is operating while intoxicated second offense notice.
Okay, can we change that in the system, Mr. Flanagan? Because that's confusing to me. So operating with a high BAC second offense notice and operating while intoxicated second offense notice, and then disobeying the lawful order of a police officer. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Rakidia Hall, P number 82954 on behalf of Brittany Echols. Ma'am, may you unmute yourself and state your full name for the record, please?
Yes, good morning. My name is Brittany Danielle Echols.
All right, today is the day set for pretrial conference. Ms. Hall, how are we proceeding?
Your Honor, Ms. Echols would like to continue her not guilty plea. We would like to request a date for a final pretrial, and also we would like to request discovery.
The court is going to continue a not guilty plea on behalf of Ms. Echols, set the matter for a final pretrial conference. March the 8th. At 9:00 a.m. Discovery should be submitted by February the 8th. Bond will continue, and the court is going to add urinalysis 4 times a month, unless she's currently on a tether, on an alcohol tether. Quite frankly, I think I'm gonna add an alcohol tether, actually. Miss Hall, your client wants to speak.
May I go in a breakout with her? I'm not sure what she wants to say.
Well, if she's answering my question about the tether, I guess she could go ahead and answer the question. Okay, go ahead and unmute.
Yes, Judge Bryant, I am on a alcohol tether.
Okay, so she's going to stay on the alcohol tether. And let me make sure that I didn't get any reports of non-compliance. Nope. Okay. So currently she's all set. Then the bond continues, and it includes the alcohol tether. And then we're all set until March 8th yes, ma'am. Unmute.
Judge Bryant, there was a ruling by the previous judge that I was in front of that I can't drive. I was wondering if that could be re-looked at or revised or.
Yes, ma'am. So one, the court will modify the bond to indicate no driving without a valid license. So if your license is valid, which I might think it is not valid, but that's not my issue. That's between you and the Secretary of State. These charges, I think, brings an automatic suspension. So my bond condition as to driving is no driving without a valid license. So Mr. Flanagan, you can modify that. But if your license is not valid and you need to check with the Secretary of State, then you can't drive if your license isn't valid. Okay?
Yes, ma'am.
All right. Then we're all set. Have a great day. Stay safe.
Well, thank you.
All right, let's see who this telephone is. Can the person with the phone number ending in 2632 unmute and state your name for the court? Can the person whose phone number ends in 2632 press *6 to unmute and state your name for the court?
Tyrese Walker.
Mr. Walker, why are you on a non-video telephone device?
Well, my phone usually do the video. I tried to go on there again today, but last time we talked, I used the same device. I don't know why it wasn't going through.
You said the last time we talked. We didn't, there's no last time we talked. You mean the last time you appeared for court?
Yes, ma'am.
Okay, so then if your phone isn't working so that you can appear in court appropriately, that means you have to come to court in person. Zoom is the privilege of if I can attend correctly, but if you can't, then you have to come in person. I'm going to send you to the breakout room and they can try to see if they can get you on video, Mr. Walker, but I'm not going to do your case with you not on the video device. So I'm going to send your phone to breakout and a lawyer will come in to speak with you.
Okay.
Please state your name for the court. Please unmute and state your name for the court.
Curtis Dyer.
Mr. Dyer, I'm going to send you to a breakout room. The lawyers will be in to speak with you shortly.
Okay, thank you.
You're welcome. Please accept to join the. Okay. Mr. Flanagan, do you know who this is at the jail?
Your Honor, that should be Marlon Howell.
Ms. Stevenson, are we ready on Little and Dyer and Jones?
I'm ready on Jones. I'm ready on Dyer. I need to read the report on Little again. I will be ready on Little momentarily, Your Honor. Definitely ready on Jones and Dyer. And Judge Crowley was improper.
Oh. I don't think so. So let me say this. The last time Mr. Crowley was here, he was not improper. He said he was improper, then he said no, then he let Mr. one of them represent him. Because I said I wasn't gonna keep going back and forth with Mr. Crowley. Mr. Crowley is not improper.
I thought we got removed as counsel.
When? What date?
One more time.
Mr. Flanagan, when was Mr. Crowley here last?
He was here last on October 27th, and the order to remove MFD as counsel was signed October 31st.
Oh, so who's his lawyer? You all still have Stevenson on here, then you got to take that off. Did I say I was getting him somebody else appointed or no?
I don't have that information, Your Honor.
Okay, let me look at my notes. Oh yeah, I do have that in my notes. Is anyone else in the breakout room? Because I need to shut him down. He's not coming out. Nope. All right. All right, I'm ready on Jones then.
Your Honor, just so you know, the Samsung SM that you were letting in but wasn't able to hear or say anything, that was Tyrese Walker.
Okay, well, I know I told Mr. Walker he could live in Alabama if he was able to come to court. Okay, so if he's not able to come to court, then he's not able to live in Alabama.
I understand. He is back in the waiting room and hopefully he'll be able to connect. I walked him through that process.
Okay. State your name.
Tyrese Walker.
All right, thank you. Please accept to join the breakout room. Whoops.
Say it again.
We are all set, Your Honor. I don't need a breakout.
Oh, okay. All right. Can you change his name then?
Yes.
All right, let me start the videos.
Kind of low. I can't hear.
All right, I'm ready on Crowley. This is case number 22-452-2201, the people of the state of Michigan versus Reuben Crowley. The defendant is charged with 1 count of trespass, and today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Mr. Crowley, your name, please.
Reuben James Crowley Jr., appearing on behalf of myself.
Today is the date set for a final pretrial conference. How are we proceeding?
Is that question to me?
Yes, Mr. Crowley. How are we proceeding?
I haven't had a chance to speak with the prosecutor, but I do have information that she should be privy to prior to us holding this examination.
There's no examination to be held. No examination to be held. Lawyers are responsible for talking to the prosecutor before they come to court. Before they come to court.
I've been trying to contact her through the prosecutor's number. I called several times, and they told me that they would not disclose who the prosecutor was to me. And when I reached out to the court, I did.
Crowley, they didn't have to disclose it to you because the last time you were here, we disclosed it to you. She was here and we gave you the phone number because you're going to be representing yourself, and she got your email address. Do you recall that?
Yes, I do, Your Honor. As a matter of fact.
So, and then Ms. Ritter, did you send him the discovery?
Judge, I sent over video discovery on October 27th to the email provided, and I also sent paper discovery on that day as well. And my contact information is always attached on my signature when I send discovery.
So you had her information, and then you could have just responded to the email that she sent you. So you've had an opportunity to speak with the prosecutor. So how do you wish to proceed today?
Well, at this point, I'm still pleading not guilty. I haven't done anything wrong. I've never tried.
I'm going to continue the not guilty plea on behalf of Mr. Crowley. Set the matter for a jury trial. The court is going to set a jury trial for what happened to my phone?
I see a prompt to join a breakout room. Am I supposed to join this room?
Sir. No, that wasn't. I don't know what.
Okay.
Go to jail. All right, court is going to set a jury trial for Monday, June 17th.
Your Honor, may I ask a question?
You may.
Now, if I have exculpatory evidence that would demonstrate.
Mr. Crowley, let me interrupt you and say this. You're representing yourself. It is your responsibility to know how to represent yourself. I cannot give you any advice on that. I cannot give you any instruction on that. You are representing yourself, and therefore you have to be responsible to know and understand all the things that lawyers go to school for years to learn. You have to be responsible to know those things. So I'm not going to give you any instruction on how to do anything as it relates to this case. You're going to have to figure that out for yourself. We provided counsel for you. You rejected that counsel and indicated that you want to represent yourself. And so you have to do just that, represent yourself. Okay.
Okay, is this an opportunity for me to make a motion for dismissal?
Mr. Crowley, you have to know how to represent yourself.
Okay, I would like to make a motion for dismissal on the grounds that there's no evidence that demonstrates that I trespassed that was provided to me by the prosecutor.
So I don't know how you know that when you didn't even look at the discovery that the prosecutor sent. But number two, as I did on October the 27th, the court is going to was it October 27th or something? Court is going to deny the oral motion. However, I will set a motion cutoff date. There was a motion to dismiss requested on October 27th. At that time, the court denied the motion, indicated that the people must produce the evidence to Mr. Crowley. The people have indicated that they have done that. Court is going to set a motion date. So first, I'm going to set the jury trial for June the 17th. Jury trial 2024. That's at 10:30 a.m. Court is also going to set a final pretrial conference and motion hearing date of May the 16th. So the final pretrial conference. And motion hearing May 16th at 11:00 a.m. Defense must file a written motion. The motion must be filed by, so that's, what did I say? Final pretrial May 16th, so that means 7, 14, 21, and then 11. Okay, so any motions must be filed by Thursday, April the 4th. And then if received by the court and the people by April 4th, then of course the people will have until April the 25th to respond. And then any rebuttal would or reply would be filed by, whoops, 1, 2, 3, by April 30th. I'll set it for May 1st. Response by May 1st. Or reply, I should say, reply by May 1st. With a motion hearing on May 16th at 11:00. Anything further?
Yes, yes, Your Honor. I'm looking at the email that was sent to me by evidence.com from the Wayne County Prosecutor's Office. There is no contact information on this email that I have related to the evidence, the video evidence that was sent on October the 29th, 2023 at 9:40 a.m. There is no contact information here. That's why I was calling the prosecutor's office to get the contact information. Can the prosecutor provide me with her contact information?
Ms. Ritter, can you give Mr. Crawley your contact information that's in the bar journal that every other person would be able to go get? Can you provide him with the contact information that's in the bar journal that's available to the public?
Yes, Judge, I am sending an email now with my contact information.
All right. Anything further?
No, thank you, Judge.
No, thank you, Your Honor.
All right, then we're going to be all set until May the 16th at 11 o'clock for any motion hearing and final pretrial conference. Everyone have a great day, stay safe, and Happy New Year.
You as well, Your Honor. Thank you.
Thank you. All right, I'm ready on Jones. And then I'll do the reviews. I mean, I'm sorry, I didn't mean that. I'm ready on Jones and then Howell, and then I'll do the reviews. I need Mr. Jones to start his camera, or I'm going to move on to Mr. Howell. Okay, this is case number 224472601, the people of the state of Michigan versus Alexander Jones. The defendant is charged with one count of retail fraud, and today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Alexander Jones. Mr. Jones, sir, please unmute and say your full name.
Please unmute.
Yes, can you hear me?
First, state your name.
Alexander Jones.
Today is the date set for final pretrial conference. Ms. Stevenson.
Thank you, Your Honor. Mr. Jones will continue his plea of not guilty. Matter is currently scheduled for jury trial February 6th, Your Honor.
All right, the court continues the not guilty plea on behalf of Mr. Jones and continues the matter to a jury trial February 6th. Anything further?
No, thank you, Judge.
Nothing on behalf of Mr. Jones. Thank you, Your Honor.
Actually, hold on one second. I apologize. Let's see. What happened with Cheeks on November 14th?
I believe that was rescheduled, Judge.
Why? Rescheduled for what? It's on for jury trial. Rescheduled for what?
I think he retained counsel.
And Mr. Flanagan, what's his date? Because retained counsel was supposed to be ready to go to jury trial on February 6th.
On November 14th, it was scheduled for a final pretrial on January 17th.
So that's coming up on January 17th.
Yes.
All right, well, we might have two jury trials that day because I'm not adjourning that one. So this is January 17th. All right, then we're going to continue. Mr. Jones is a go on February 6th. Have a great day. Stay safe. And we'll see you February 6th at 10:30 at 36th District Court.
Thank you, Your Honor.
You're welcome. I'm ready on how this is case number 194428401, the people of the state of Michigan versus Marlon Jermel Howell. Defendant is charged with one count of assault or assault and battery. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Marlon Howell. Mr. Howell, sir, please tell the judge your full name.
Howell.
Say your first name again for me.
Marlon, M-A-R-L-O-N.
Oh no, I didn't say spell. I didn't say spell your name, Mr. Howell. We know how to spell. I asked you to say your name.
Marlon Howell. I apologize, Your Honor.
That's okay. Today is the date set for sentencing. Even though this matter is scheduled at 9 o'clock, I don't believe that there would have been a pre-sentence investigation. I feel like this should have been at 8:59. So with respect to Mr. Howell, is there anything from the people with respect to sentencing?
Judge, with respect to sentencing, I do understand that Mr. Howell has been in custody in the Wayne County Jail for quite some time. I did have discussions with sister counsel that the people would agree to credit for time served. If I was provided, I don't remember, and Ms. Stevenson, correct me if I'm wrong, I don't remember being provided proof of how long Mr. Howell has been incarcerated, but if that satisfies the people have no objection to no credit for time served.
The information I had is that was provided to the people at through the deputy who was present at that time, and I don't have the numbers with me. I apologize for that. But the deputy gave us that information at our last hearing, and I thought we were just for today to give the complaint or the now victim the opportunity to be present for sentencing.
That sounds like my memory as well, but Mr. Howell, can you summon for the deputy? Can you just ask the deputy to come into your room? Oh.
Yes, Your Honor. He's been in custody since November 7th.
Okay, thank you. Yes. Okay. So I believe that today was only I wasn't willing to give him credit for any time served because the victim has a right to make a victim impact statement. Officer Crafts, has anyone checked in for this case in person?
No, Your Honor.
All right, so is there anything further on behalf of the people?
Nothing further, Judge. Thank you.
All right, and anything further on behalf of the defense?
Nothing, just that Mr. Howell be given credit for time served and the matter be closed, Your Honor.
Court is going to sentence Mr. Howell to 60 days in the Wayne County Jail, credit for 60 days closed. Credit for 60 days served, and the matter is closed. Anything further?
Nothing further, Judge. Thank you.
Nothing on behalf of. Thank you, Your Honor.
All right, Mr. Howell, then as it relates to this case, you're all set, sir, okay?
Yes, ma'am.
All right. All right, then I'm ready on, whoops, what's that? I'm ready on, what is my computer doing? Okay. I'm ready on Dyer. This is case number. Okay, hold on. Ms. Stevenson, I sent you something on Dyer, didn't? Oh, wait, there it is over there, I think. Okay.
Dyer.
I didn't send you anything on Dyer?
I saw something on Little. I'm gonna check again.
You saw something on Little? Oh, I have, wait a minute. I sent you something on Walker. Oh, why do I have something?
I saw this on Dyer. Yes, you did send it to me and I saw it. Get my tablet.
This is Little.
Your Honor.
Yes.
Is it okay if I step away very briefly?
This is Walker. Yes.
Thank you.
Well, I can't find my stuff on Dyer. Hold on. All right, let me pull up Dyer again. I don't have, for some reason I don't have it. Let me pull it up again. All right. Oh no, I don't have anything on that. You're saying I have someone Dyer?
I
What did
saw
you?
something. Let me. 1 second.
No, I don't see anything. Wait a minute. Hold on. Let me look it up. Sometimes Miss Tucker's don't. Let me do it a different way.
Oh, no, Judge, this is the old one.
Okay, right. Oh, no, but I do have something. I didn't send it to you.
No.
Okay, let me send it to you. I'm sorry. I do have something. For some reason, Miss Tucker's don't always show up in my search. Okay, so this is case number 22452-0101. The people of the state of Michigan versus Curtis Dwayne Dyer. Defendant is charged with 1 count of license plate illegal use. Today is the day set for sentencing. Ms. Stevenson, your appearance, please.
And it's Stevenson appearing on behalf of Curtis Dwyer. Mr. Dyer, sir, please say your full name.
Unmute.
Curtis Dwayne Dyer.
Today is the date set. Oh, what happened to Mr.? Today is the date set for review. I do have an update from Ms. Tucker, and it appears that Mr. Dyer has completed all the terms and conditions of his probation and that he is ready for, whoops.
Judge,
hold on.
You sent me Raheem Hill. And
I did. That's wrong. I'm sorry. It's not what I meant to send you. And I'm looking at the wrong one.
Okay.
So hold on. I'm sorry. And oh, you know what? Maybe that's what happened. Actually, maybe Miss Tucker. Hold on. That was Hill, and yeah, that's what's wrong. Okay, can you call Miss Tucker? Because this is not like her. She usually sends me an update. So call Miss Tucker and see if she has an update on Dyer.
Okay.
All right, so I'm ready on Walker and I'm ready on Little. Mr. Little, come up to the podium, please. Mr. Dyer, just give us a moment. All right, this is case number 185899501. The people versus Dwight Elliott Little. Defendant is charged with 1 count of controlled substance illegal use. Today is the day set for review. Ms. Stevenson.
Janice Stevenson appearing on behalf of Mr. Dwight Elliott Little. Mr. Little, sir, please say your full name.
Dwight Elliott Little.
All right. Today is the day set for review. I don't like what I see. This is an old case. Probation was reinstated in September. He's done nothing. This is horrible. This is unacceptable. Probation has not been able to get in touch with him. It is my thought to revoke his probation and sentence him to jail. Ms. Stevenson?
I would ask the court not to do that, Your Honor.
Why?
And because Mr. Dwyer, excuse me, Your Honor, because Mr. Little, if nothing else, has presented himself as he was ordered to do by the court. I did today in person. I checked.
Hold on
We
one
have
second.
this.
Hold on. Mr. Walker, you appear to be in the bed to me, and I need you to get out of the bed. I need you to get out of the bed and go to a table, go sit in a chair, something, but I need you to get out of the bed, Mr. Walker. Okay, Ms. Stevenson, it's unacceptable that Mr. Little just is showing up for me. He's done nothing. I reinstated his probation in September. Probation has not been able to reach him. Probation has not been able to get in touch with him. He has failed to report monthly to probation. He has failed to complete outpatient treatment. He has failed to test twice a month. He has failed to do Narcotics Anonymous. He has failed to do 20 days of community service, and he has failed to pay $535. He has failed. His probation is revoked. It was a reinstated probation. It was a reinstated probation. He has shown me that he didn't want his probation reinstated. So I'm revoking it.
Your Honor, would the court give Mr. Little an opportunity to demonstrate to the court at least that he doesn't have any, that he would test clean? I don't know if we have any substance abuse
I
issues
don't want him to test
remaining.
clean. Nope, I don't want him to test clean. I wanted him to test clean between September and December. I wanted him to test clean. I wanted him to test. I wanted him to participate. I wanted him to put some skin in the game. I wanted him to do something to show me that he was worthy of me reinstating his probation. He has done nothing. I mean, zero. I'm talking about zilch. He's done absolutely nothing since I reinstated the probation in September. This is absolutely unacceptable.
Except make it back down here to the courthouse, Your Honor. And I'm
coming to court is not a condition, is not a part of his probation. I'm talking about the probation. Coming to court is coming to court. Every person who is a defendant in a case has a court date. I'm talking about complying with the terms and conditions of the probation that the court has set, because we all know that probation is the alternative to jail, and jail is the alternative to probation. This defendant, Mr. Little, has shown me that he wants the alternative to the probation, and that is jail. He has done nothing, zero, zilch. And I know if I call Miss O'Driscoll and ask her for her opinion, she's going to say, Judge, I can't work with him. I go ahead and put him in jail. He's not a candidate for probation. So coming in here, coming to court and acting like, oh, that's what all I need to do. No, absolutely not. Absolutely not. This is Mr. Little on a 2018 case. I don't even know how much time he actually still has on a probation. But we've been dealing with Mr. Little since 2018, and then he came in to see the court. Well, he was sentenced in 2020. So he was sentenced 3 years ago to 12 months. And here we are in 2024, right? January 2024. He's done that. Sure, you can try, Ms. Stevenson, but I have a verdict to give, so you could try.
I understand, Your Honor, and I certainly appreciate the court's frustration with Mr. Little's lack of compliance, utter lack of compliance with this court's order. I don't believe that incarceration is the only sentence available to this court. I would argue that this court does have the power to sentence Mr. Little to a term of probation as a consequence of probation violation. And I think that would give Ms. O'Driscoll and the other staff over 36 District Court probation the opportunity to continue to work with Mr. Little, who, Your Honor, unfortunately, I have to say that I have a number of clients who don't even come to court, that if they're not going to do the probation, they follow this court's other instructions, just don't show up. Mr. Little's not trying to do that. He's not thumbing his nose at this court. He's not being that disrespectful of this court's order. He did show up today, and I do believe that counts for something, because he didn't have to do that. He was ordered to, but he didn't have to do that. So I think that shows that he's trying to do something to come in.
You're trying to keep on talking over me, but you know I'm not going to let you. You're going to try to.
I didn't hear you, Judge. I didn't hear you.
I was like, I really like you and respect you as a lawyer, but I'm not going to let you keep talking on me. What you started saying sound like to me when an abuser come and tell their abused person, well, I didn't beat you Wednesday. I beat you Tuesday. I beat you Sunday, Monday, and Tuesday, but I didn't beat you on Wednesday. So be grateful. And then I might beat you on Thursday. That's what you sound like with that argument to me.
I had to try something, Judge, and he's here. And he's here.
Well, I'm so glad he's here. Mr. Officer Crash, you could take him to the back. I'll recall his case later.
Thank you.
You can take him to the back right now. He going to jail for 93 days. That's what's going on in my mind right now. All right. Miss Tucker just sent me something on Dyer. Hold on.
Be on Dyer.
Let's see what she said. Oh, he's done nothing too. All right, recalling Dyer. Let's, I guess we starting out the year with a bang. Case number 224520101. Mr. Dyer has done nothing. We're back on the
Janice
record.
Stevenson appearing on behalf of Curtis Dyer. Mr.
I
Dyer,
didn't ask you for your appearance. We did appearances before?
I did not think so.
Oh, okay, go ahead.
Okay, Mr. Dyer, sir, please tell Judge your full name.
Curtis Dwayne Dyer.
I extended Mr. Dyer's probation too. And I extended his probation last year in May. And then we came to January. He's done nothing.
You
He's done nothing.
extended him to February 1st?
Well, I mean, so okay, so let's talk about that, Ms. Stevenson.
Okay,
all right.
Judge.
So I extended him to February 1st.
Yes,
No, and in fact, I didn't. His original probation term was February 1st, 2023. I extended the probation for 9 months on May. Oh, so you saying the 9 months will end February 1st?
Yes, Your Honor.
Okay, and
$315.
He has $315 to pay. He has 3 active warrants, 2 in Woodhaven and 1 in 27th District Court. We're going to adjourn to February 1st. That's it. That's all. That's the end of it. We're adjourning to February 1st. That's it.
Okay.
Anything else beyond that is no. It's negative. It's a 0.
We are very grateful. Thank you, Your Honor.
All right. Sir, you're all set till February 1st. Have a great day. Stay safe.
You too.
Mr. Walker, turn on your camera. Let me see. I hope Mr. Walker say something different, because I'm sure gonna hate to tell you to come down there and go to jail too. Let's see.
Your Honor.
Hold on. This is case number 204549701. The People versus Tyrese Benito Walker. Defendant is charged with operating while intoxicated. Today is the date set for review. Oh, he got time left. Thank you, Lord. Appearance, please.
Good morning, Your Honor. Rakedia Hall on behalf of Tyrese Walker. Sir, may you state your full name for the record?
Tyrese Benito Walker.
All right, Mr. Walker. Today is the day set for review. Now, Mr. Walker, you've been sitting in this Zoom. You know what time it is, okay? Mr. Walker has viewed the consequences video. Thank you. He has completed the alcohol highway safety. Thank you. He does have some remaining conditions, but he is not scheduled for discharge until June 10th. I'm so happy.
Me too.
I'm so happy. I'm so happy. Okay, so Ms. Hall.
Yes, Your Honor. Mr. Walker, he does have time left. He has been making efforts to complete the conditions required by the court. As the court knows, he is in Alabama caring for his father. He has been doing the drug urinalysis. He has not attended the victims impact panel and or paid the costs and fines. He just got a job about a month ago, but it's so unsteady. He only worked 1 day this week. So he is trying to do his best to do what he needs to do to pay for the victims impacts panel and also pay the fines and costs. So he's trying. So we're just asking for another review date to give him more time to complete the remaining conditions.
All right, couple of things. Number one, he needs to ask me now for community service if that's what he wants. He can do community service in Alabama at the major places, Salvation Army, Red Cross, those places that the probation department know can be verified if he wants community service. Additionally, he has time to do the victims impact panel. And then one other thing though, he's been testing, but twice he went the next day. So let me be clear, Mr. Walker, you waste your money when you go to a drug test the day after they ordered you to go. Like that, the money is completely wasted. It's like just shredding the money and throwing it into the ocean. Why? Because I don't care about what the results said on the 19th. When they told you to go on the 18th, those are the only results that I was interested in. When you said I'm gonna go the next day on the 19th, I didn't even care about what the 19th results said, because whatever was in your system on the 18th, we don't know. Because now the 19th could have just been the critical day. the day where it was all out of your system. So I need you to make sure you go on the day that you're supposed to go. I am going to reduce him down to once a month, and I need him to ramp up payment or request community service. So anything further? And we're going to just continue him to the final review.
Thank you. Your Honor, may I just ask Mr. Walker, would you like to have community service in lieu of paying the costs and fines, or would you like to just take the time to see what you can save to pay the remaining costs and fines?
No, I just rather pay it.
Okay.
All right. Well, you're still in good standing right now, Mr. Walker. Okay.
And thank you, Your Honor.
All right, you're welcome. Okay, then we're going to continue to June 4th. Mr. Flanagan, is he on the docket for June 4th? Hold on. June 4th, I sound like I'm going to be on some island. Wait a minute. Let me make sure I'm still available. Hold on. What did I say? June 4th?
I don't have it on my schedule. I don't think we're going anywhere.
Oh, well, let me say something. On June 6th, I'm going to be on the sunny shores of Jamaica. So I thought that was sounding close to it. Okay.
Sounds like a plan to me. Let's go.
I don't know what's on your schedule, but on mine. Okay, so June 4th is good. June 6th would not be. So we'll continue to June 4th at 10 o'clock. Anything further?
No, nothing further. Thank you.
Thank you.
All right, and that's Mr. Walker. Okay, June 4th. All right. Have a great day. Stay safe. Happy New Year to you, sir.
Yeah, same to you.
All right.
Thank you.
You're welcome. Miss Ripley, are you there? Good morning, everyone.
Yes, good morning, Judge.
All right. Thank you all for your patience and indulgence. Ms. Stevenson's clients were not doing their probation, so they took me over. Okay. Ms. Stevenson, you might want to go in the back over there in that door.
No, that's exactly where I'm headed, Judge.
Oh, okay. Go in the back and talk to your client, because it looked like somebody got to feed the dog for 93 days or something. Okay.
Go see what I can work. Find me a prayer closet.
Okay. All right, I'm ready. This is case number 23. Mr. Officer Crafts, are there any individuals in the hallway? I know there were some people here the other day. I don't know.
Let me go check right now, Your Honor.
All right, but okay, this is case number 2344667. No, 234466701. The people versus Ramon Vicente Pilgrim, and the defendant is charged with 1 count of child abuse, 4th degree, 1 count of assault or assault and battery. Today is the date set for the continuation of the waiver trial for the court's verdict. Appearances, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
And may it please this honorable court. Good morning. Byron Pitts, ready on behalf of Dr. Ramon Pilgrim, who consents to having this hearing by Zoom and sits right next to me and appears on Zoom with me.
And sir, state your name.
Dr. Ramon Vicente Pilgrim.
All right. Okay, today is the date set for the court's verdict, and I'm going to just even start out by saying that this is one of the most difficult cases, and that I've taken to conclusion. Right. Of course, I've been on the felony docket, so I've heard, obviously some cases that have been much more catastrophic and that sort of thing. But in terms of my decision, and why do I say that? Because I believe that this particular decision actually impacts a lot of issues. And there was some of the things that was said in the closing argument by the defense as well as the people, and some of the poignant points that were made by the defense. And so I want everyone to, first of all, know that I did not take this decision lightly. In fact, I got up even this morning and I was re-looking at the video evidence and trying to consider the court's decision with respect to this particular trial. And as I looked again this morning at the video evidence at least 5 times, I concluded that there is so many things about this case that really bother me. I didn't bring my court rules home with me, but I think I kind of know the rule by heart a little bit. But the people have the burden to prove beyond a reasonable doubt. Where did I put it? That Mr. Flanagan, what's the date? What's the date of this offense? Alleged offense? Well, the date of the offense, but rather he is guilty of what they said. I should know it.
It's September 22nd, Judge, if I could chime in.
Yes, that's what it is. Okay, September 22nd, 2023.
2022, Judge.
22. The people have the burden to prove that within the city of Detroit, county of Wayne, that Mr. Pilgrim committed one count of assault or assault and battery, and then one count of child abuse, 4th degree. In order to meet its burden, the people submitted a couple of witnesses, and then the defense gave up his right to remain silent, and he testified. And then there was also one other witness on behalf of the defense. Let me tell you some of the things that bothered me. The court rule also indicates that when a matter is tried by the court, unlike a jury, the court is supposed to give its findings of fact with respect to its verdict. I guess because there's no one deliberating with the court, they want us to give a rationale on the record, I suppose. So there were some things about this case that bothered me. And one of the things about this case that completely bothered me was that no one reported this incident from September to November. So whether Dr. Pilgrim's actions were right or wrong, Mr. Let me pull up my notes because I'm not good at names. Mr. Grisham. Mr. Grisham was present during this incident, and whether Dr. Pilgrim's actions were right or wrong, no one even reported the use of force. Not Dr. Pilgrim, and not Mr. Grisham. What do you mean by that? At the police department, in police incidents, when the police use of force, whether it's a legitimate arrest or whatever is going on, they have to report the very use of force. This was a child, and nobody ever even reported the use of force. That's the first problem I have with the case. And then the second problem, one of the other problems that I had, was that everybody talked about the protection of the children. And I definitely want to protect the children. Everyone almost talked about the protection of the children. I got to protect the children, the children. And then Dr. Pilgrim went so far as to call some of the children his babies. He said, I got to protect the babies. Yet no one reported to the police, or as far as I'm aware, so I should say the evidence did not reflect that anyone reported the threats made by Mr. Isaiah Ashford. No one reported those threats. And in a day and time where we know that threats can definitely turn into violence against students, against the school, against teachers, no one took the time to even report those threats that were being made by Mr. Ashford. The evidence did not reflect that anyone sought to get help for Mr. Ashford. The record did reflect that Mr. Ashford apparently, allegedly got in trouble again, because that's how Miss Perkins became aware, because he was in her office on a suspension. So she became aware, and this is in November. Okay, so that's what the court was observing with respect to those things. So now I get to the actual incident. So now we have what clearly appears to the court to be a troubled child. There's no dispute that on the day of this incident, the child was combative. He was angry. He was fighting. He was doing these other things. I don't believe the record disputes those facts. So the child is combative. His behavior is inappropriate, and his behavior is unacceptable. And so in comes Mr. Grisham. Mr. Grisham breaks up the fight, and he grabs the child. So Mr. Grisham, he grabs Isaiah by around his arms. So the video shows, and I don't know why Mr. Grisham was trying to downplay the fact that Isaiah was combative. I don't know. But you can clearly see on the video that Isaiah is combative. He's not voluntarily walking into the auditorium, right? So he is combative. And then Mr. Grisham holds him by the arms, and then he plops him down in the chair. Right behind Mr. Grisham on the video. So now I'm just talking about what I see on the video. Right behind Mr. Grisham, Dr. Pilgrim is like just steps behind him. So it's not like, he's farther away. Dr. Pilgrim is steps behind him. Mr. Grisham puts the child in the chair, and then the child, almost as soon as Mr. Grisham releases him, the child jumps up, and he's getting ready to leave out of I apologize for saying he's getting ready to leave. He turns to move. He turns to move. Immediately, almost instantaneously, when the child gets up, Dr. Pilgrim lurches into action. And when I say lurch, I mean lurch. He lurches into action. The child gets up. Dr. Pilgrim lurches into action. He lurches towards the child. I watched the video this morning. I told you I watched it about 5 times. I watched the video yesterday too. And I kept saying, sometimes when you hear a lot of testimony, you got to make sure that you're not seeing what you want to see, but that you're seeing what is actually going on the video. So I watched the video several times. And in watching the video several times, I do not agree with the defense's recitation of where Dr. Pitt's hands were. In fact, when I looked at the video again this morning, it is the court's conclusion, and I wrote this down, that it almost looked like a karate chop, that to the left side of the child, it almost looked like an initial karate chop of this upper part near the neck, and then a pushing back into the chair, so much that the chair, I don't know if the chair broke. I don't know what the definition of broke is. I don't know if those chairs rock back and forth. That there was no evidence on the record, but the chair remained in a backwards position once Isaiah moved forward. Additionally, the court looked at the video to see that Mr. Ashford, after whatever occurred, after the incident, Mr. Ashford does double down on the ground. He doubles down, and he appears to be, because there's no camera facing him, he appears to be out of the chair and on the floor. And I don't know what he's actually saying, because Mr. Grisham said that he was saying, "I can't breathe." Now, the problem I have with Mr. Grisham is that a person could see what I saw on the video and at the very least did not immediately report that. I also have a problem with the fact, according to the defendant's testimony, that the principal of this school, and I'm only taking the facts as they were presented to me, would say, go get statements about a situation that you were involved in, whether or not you were the target of the investigation. Go to your subordinate and secure a statement about actions that you were involved in. But the fact that Mr. Grisham would say that he left something out of his statement because he had to give it to his boss is appalling to the court. That testimony is appalling to the court because we are supposed to be protecting the children. I don't believe anybody in this situation was protecting the children, not Isaiah Ashford and not the kids on the playground. Isaiah Ashford appears to this court to be a difficult, unruly child who is in need of probably some mental health treatment. But what we as adults and as educators and as people in charge of these children have to be careful of, hurt people hurt people. So if we're the protectors, we can't then become the predators. If we're the protector, we can't then become the one doing the hurting. Now, defense made some excellent points, and I don't know the motivation for this prosecution. Anyone that knows me knows that I bring attention to all as much as I can to places where I think there's injustice, to places where I think there may be unbalanced prosecution. I didn't see it in this instance. I didn't see it. But what I saw is something that came to somebody's attention months later, and now they have to address it. I agree with Mr. Pitts that if Dr. Pilgrim didn't do anything, he probably would have been charged under the second theory under here, that the defendant's omission or reckless act caused physical harm. If he didn't do anything, it would have been omission. We walk a thin line, but when we walked a thin line, I saw several things that could have been done instead of what was done. Monday morning quarterbacking is always, something that we could do once we look at the video. But when Mr. Ashford was walking away, he could have got grabbed on the back of his clothes. Sit down, young man. Don't move. Stop it right now. If you move out of we are going to call the police. Mr. Grisham, go call the police. Mr. Ashford, remain seated. Another bear hug while we call your parent, while we call the police. I don't know where his parents are. And you're right, Mr. Pitts. If I came home, told my mother a teacher choked me, the school probably wouldn't even be there. It wouldn't even be there anymore. And she'd probably be in prison. I probably have to be going to visit my mother to this day because she's still living and she's 86 years old. And she'd probably be in prison if I had come home and said the teacher choked me. And then it's on video. I don't know where Mr. Ashford's parents are. But Dr. Pilgrim, I think that your contact with Mr. Ashford was aggressive, and I believe it was excessive. And therefore, with respect to both counts 1 and 2, the court does find you guilty of child abuse 4th degree, as well as assault or assault and battery. And that is the court's verdict. We're going to set the matter for sentencing. Is the child abuse 4th degree, that's a 1-year misdemeanor? Or 93-day? Are they both 93-day misdemeanors? No. I mean, the chances of it mattering is probably slim to none, but
it's a 1-year, Judge. That's the only difference.
Okay. I'm going to set the matter for sentencing. I mean, nothing about Dr. Pilgrim says to me that I would ever sentence him to the 1 year. I mean, it's a penalty that's out there. I suppose should he not complete a probationary period, and should, as I anticipate, perhaps I don't speak for Mr. Pitts, but as I perhaps anticipate that there may be an appeal of the court's verdict, but I'm going to set the sentencing. Now, I do know that the victim did not show up at the trial. I don't know the reason, but I do have to allow for victim impact statements. I also don't even believe, but if someone wants to request one, I will order it. I don't believe that I need a pre-sentence report for Dr. Pitts. If anyone, I mean, I think I don't believe you think he has any criminal history, Ms. Ripley, do you?
Judge, the only criminal history that we know of is what's on his.
Oh yeah, and the
so
yeah. So are the people requesting a pre-sentence investigation?
Judge, if it's not necessary, I don't think that we need.
I don't think I need one. But I do, as I indicated, I do have to allow for the victim, should he choose to give a victim impact statement. And that would also, extend to his parents or whatever. I don't know what that situation is. So what about February the 22nd or 23rd? Are either of those days good?
The 22nd works for the 22nd. We're checking, Judge.
Okay.
Yes, Your Honor, that works for defense.
Okay, so I'm going to set the sentencing.
Sorry, Your Honor. I started jury trial on the 20th.
Okay, do you all go on Fridays? I know some judges don't.
No, we wouldn't. I think it would be done by the 22nd.
Okay, well, let's set it for the 23rd though, just in case. Is the 23rd, is that good?
Yeah, it should be done with it. If anything, the jury will be deliberating, so.
Okay. Let's set it for the 23rd. Dr. Pilgrim, you have a right to be sentenced in person. You may consent to being sentenced on Zoom. Which do you prefer?
I'll do Zoom is fine.
All right. And then the court sets it at February 23rd, 9 o'clock on Zoom. And then, of course, at that time, I'll specifically state the appeal rights on the record. Anything further?
Not on behalf of the people, Judge. Thank you.
Nothing on behalf of Dr. Pilgrim, Your Honor.
All right, then we're all set. Everyone have a great day and stay safe.
Thank you, Judge. You too.
For some reason, I don't have I did. I sentenced Howell. Okay. All right. Ms. Stevenson, all right, you ready? You want to go back on the record with Little?
I do, please, Your Honor.
All right. Ms. Ritter, we could go ahead and do the dates. Well, it looks like maybe no one needs dates. Did Neil, if Neil Capias before, that's a Capias, and then Hearn and Merida are Capias.
Okay.
Okay, Josh. Thank you. Have a good day. Have a good weekend.
You also.
Have a nice working weekend.
Whatever. Wait a minute. Did we conclude that I have to be in the building Monday? Wait a minute.
Yes.
We did. Judge.
Oh yeah, those cases are going. Okay. Yes. Bye, Miss Ritter.
Bye.
Judge, you ready to bring them out?
I am. Mm-hmm.
Gotcha. Walk straight.
Recalling case number 185899501, the people versus Dwight Elliott Little. Ms. Stevenson.
Again, for the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Dwight Little. Thank the court for recalling the matter. Mr. Little, sir, please tell the judge your full name.
Dwight Elliott Little.
All right, Ms. Stevenson.
So, Your Honor, I do want the court to know that, again, Mr. Little, we are asking the court to reconsider its decision to incarcerate Mr. Little. We, again, just want the court to know that Mr. Little, you know, though he has handled this probation quite irresponsibly, is not doing so in an effort, again, to disrespect this court or its orders. Mr. Little does have some significant health concerns, Your Honor. He did complete a sobriety program at Share House, Your Honor. And I think sobriety house during the pendency of this probation. So while he apparently has not given proof of that to the probation department, I guess it's not completely factual that he has failed to comply with each and every condition of probation, because I do believe that outpatient treatment was ordered by this court or by the sentencing court. So really, because of the health concerns that Mr. Little has, his vision is failing. He does not have sight in one of his eyes, Your Honor, and he's been diagnosed with glaucoma, which is compromising the vision in his other eye. He has an appointment with the Kresge Eye Center on this coming Monday, hopefully with an effort to save his sight. And I know he would like to make that appointment. In that we do have the outpatient treatment, or his position is that he did complete outpatient treatment while he was on probation or under sentence for this case. So I think he's taken some steps to try to do what he's supposed to do in terms of this court order. To be frank with the court, Mr. Little did come back to court after the capious period, because he was trying to relocate to Tennessee where he could live closer to his daughters and his grandchildren. And in order to get housing, he would have to clear up any outstanding cases. So he turned himself in. And again, you know, I agree with the court. It's everybody who has a summons is supposed to come to court, but this court knows as well as I do that everybody doesn't honor that summons. They don't comply with those summons. So I think it means something that he's here. I think it means something that he, even though he did so kind of with, so that he could get a benefit, he did bring himself back under the jurisdiction of the court, Your Honor. I would ask the court to, I don't know, have maybe a little bit better regard for Mr. Little's health than he may be having at this time, Your Honor. Let him keep
They have a
that
medical unit
appointment.
at the jail.
Yeah, but I don't know if they have an eye specialist.
They do.
And I know that's, yeah, I don't know about that. But I know that that's what Kresge does. So I'd ask
They have some eye specialists. They get eye specialists, feet specialists. The doctor come in and see all the people at the jail. But let me just say this. Let me say this, Mr. Little. I mean, I don't believe a word Ms. Stevenson is saying in terms of. I know that's what you told her, but you did. And well, I shouldn't say I don't believe a word of what she's saying, because she did say in all honesty, and then she told me some stuff that is true. You came in here for a selfish reason. That's like somebody, inviting you to dinner at the place that they want to eat at, and they got a 2-for-1 coupon. They didn't do that for nothing for you. They did that for themselves, and then probably because they didn't want to eat alone, they just invited you to come along, right? So I'm one of the most compassionate people around. Now, sometimes people don't think it, but you know me, I don't care what people think per se about me. But I'm one of the most compassionate people around. I wouldn't want to spend a second in jail. I wouldn't even wanted them to take me back there behind that gray door. I wouldn't want to spend a second in jail. I have had to tour jails based upon my work, and I didn't like it. Right? I didn't like it. I didn't want to do it. So I wouldn't want to put you in jail, especially for a person who potentially still has a substance abuse problem, but I will. And then I know defense counsel, they make those arguments about, well, judge, look, at least they showed up. Well, so what? You don't get a plus for coming and doing what you're supposed to do. You're the one with a case. You're the one. You're the one. If I just showed up to work and didn't do any work, and then when it was time for them to fire me, when I'm before the Supreme Court and I say, well, at least I showed up, what you think they're going to say? But we don't care that you showed up and occupied a seat. Sir, I don't care that you showed up. I don't care that you showed up under the risk of going to jail. I don't care, because the next time we arrest you, if you didn't show up, the next time we arrest you, one day we're going to get you. Eventually, you're going to get arrested. And then when you get arrested, the fact that you didn't show up will be a penalty to you. It don't benefit you to show up. You're supposed to show up. Your name is on the docket. It's some people whose names are on the docket. They didn't show up. Well, they're going to have a warrant out for their arrest. And when the police arrest them, if the police get around to arresting them before they die, then they just going to be in jail when they get arrested. You're not doing me any favor showing up. You're not doing me any favor addressing your substance abuse issue. You're not doing me any favor. Only way you could be doing me a favor is if we both on the road at the same time. And so the fact that you addressing your substance abuse will prevent you from killing me in a drunk driving accident. But you're the one. You're the one that was drinking and driving. You're the one that has a substance abuse problem. You're the one that showed up and said, hey, judge, give me another chance. You're the one that did that. You didn't have to come here. But you did it for a selfish reason. You could have waited until we arrested you. You could have waited until they found you. But it was selfish, the reason you showed up. But guess what? That doesn't mean you don't have to do the time for your crime. Just because you think you graced us with your presence. And so now, judge, I came. So therefore, I shouldn't have to do none of this. Well, then stay gone until we arrest you, until we find you, until we hunt you down, until you get stopped at the thing for running a stop sign, or for being in a car with somebody that ran a stop sign, and then they run your name. One of the things I used to enjoy as a young judge, I don't want people going to jail now, but it just used to kind of, do something to me when somebody was on their way somewhere important. Somewhere like the first day of their job, or a job interview, or to the daughter's wedding, and they get stopped by the police and get arrested. I don't know why that used to be like, that's no better for you. You should have came in when you supposed to come in. So there's no reward for showing up, but there is a penalty for not showing up. Mr. Little, if I wasn't going to give you another chance, I wouldn't have wasted my breath right here. But let me say this to you. Grace and Mercy have their bags packed. Grace and Mercy, the bags are packed. They out there by the door. And the only reason they on the inside of the door, because Officer Crafts keeps the courtroom door closed. If he was holding that courtroom door open, Grace and Mercy would have left out that room. So you on your last leg. You're the one that asked me for another opportunity. You're the one that said I wanted to do the probation. You're the one. Well, let me say this. They have a medical unit at the jail. Now, whether they're going to give you glaucoma surgery or not, I don't know. Whether they're going to let you go blind while you're in there, I don't know. Whether they're going to be able to, whether the service at the jail is on par with the Kresge Institute, I don't know. Some of the doctors at the Kresge Institute might volunteer at the jail. That's not my business. That's not my business. That's not something I know. That's not something I keep up with. That's the business of the sheriff. That's Raphael Washington's business. But that ain't Lynise Bryant's business. And Lynise Bryant ain't gonna, she doesn't care. Now, we're gonna call across the hall. And you're gonna make an appointment to see Jennifer O'Driscoll. If you miss one appointment, if you miss one drug test, if you miss giving some papers and proof and information to Miss O'Driscoll, if you fail to report on a monthly basis as you have been ordered to do, if you fail to submit to urinalysis as you have been ordered to do, if you fail to complete this community service as you have been ordered to do, I am going to revoke your probation. You are going to go to jail for 93 days. And then after you finish your 93 days, you can go live wherever you want to live in the whole wide world. But you're going to stop this foolishness, and you're going to stop wasting my time saying that you want to do the probation so you can go get some housing. So that's what it is. I'm going to give him a 2-month review date. We'll see what Miss O'Driscoll say, if she can verify this treatment that he allegedly did. And let me say something to you. Do not try to use the fact that you're losing your sight to say you can't do community service. We have a blind Michigan Supreme Court justice, and he show up for work all the time. We have a blind Michigan Supreme Court justice that run marathons. He runs marathons. So do not try to say, I have glaucoma, therefore I can't do community service. Oh, yes, you can. You don't need sight to answer a telephone. Now you need hearing, but you don't need sight. You don't need sight to do a lot of things that they're going to have you do. So there is community service available, even for those who have a sight problem. Now, either you want to do the probation or you don't. Either you want to take your chances getting arrested or you don't. But I'm not going to do this with you again. This is your final chance. You've done nothing since I gave you that second chance. I gave you a second chance and you crapped on me. I gave you a second chance and you still didn't do anything. I'm talking about nothing. But okay, well, let me take it back. Ms. Stevenson claimed that you did some treatment. So let me take that back. So we're going to verify the treatment. And we're going to, I don't know how he still has a $534 balance, Mr. Flanagan. So let's go to that. I mean, we could look into that right there. I don't know how he still has a $530 case balance if I gave him 20 days of community service in lieu of fines and costs. So at the most, it seems to me that he should only have a $210 balance. Those would be the mandatory costs. So just look into that. We're not going to vet it out on the record, but we are going to, Officer Krabs, you're going to escort Mr. Little to probation. I don't know if Miss O'Driscoll is available to see him today. I don't know. If she is not, because it's a drop-in, it's a, he just dropping in. Then he has to just make an appointment. So you could let the people know at the desk he needs to see Miss O'Driscoll, or just he needs an appointment if she's not available today the judge has given him another piece of grace and mercy.
Yeah.
And now he just need to follow through. Because this next time, I don't care if your surgery is going to be scheduled for the next day. You're not going to have that surgery. Anything further? All right, doesn't seem like it's anything further. Let's give him another date. I said 2 months. This is January, February, March. So let me look at my March calendar. And don't do me like that, Mr. Little. If you're not going to do the probation, just say, I don't want to do that. Let's do something else. Because then I'm saying I keep giving you chances and you won't take them. What about, it looks like I have reviews on March 14th at 1:30. Mr. Flanagan?
Yes, Your Honor. Yes, Your Honor, 3.
Okay, we got 4 now. We're going to put Mr. Little on February, strike that, sorry, March 14th at 1:30 p.m. He could come in person or he could come on Zoom. But know this, even if you come on Zoom and I say I'm gonna put you in jail, I'm gonna send the police to your house. So don't act like because you come on Zoom, I can't find you, because I can. I send the police to get you if I say I'm gonna put you in jail. So just know that. Either the Detroit Police, Chief White, or the Wayne County Sheriff, Raphael Washington. I have both of their phone numbers I got. So don't think I won't find you. Anything further?
Other than thank you very, very, very much, Your Honor. I don't have anything further. Mr. Little, do you want to say anything to the judge? Like, thank you.
I can go and tell you that I'm gonna do everything I can to finish this, to complete this. I'll be 71 on the 13th of March. And
that ain't old. 71, what that mean? It's Betty White was 90 and she was still working, 99. Let me tell you something about me, Miss Little. Excuses are not something I even allow to come into my mind. I don't allow no excuses. 71, age is a number. It's what we do with the age. It's what we do with it. But go ahead. I interrupted you.
I was only speaking that what I've been through in the 70 years that I've been living now. Making all efforts to change, I've even started back to run the church. I'm saying is my efforts to change they brought about some different things in my life. I have some difficulties, I have some problems, but everybody does. And I can only do better, try to do better than what I have done.
And you are absolutely right. Mr. Little, that is absolutely and exactly right. And the only thing that I tell people, this is the only thing I tell people. Sometimes, Mr. Little, you are exactly right. That is exactly right. That is correct. But the only thing is, sometimes people, when they get ready to turn their life around, the one thing sometimes they don't anticipate or think about or understand or accept that even though I'm turning my life around, it may be some things that I did previously when I wasn't trying to turn my life around that I now have to make penance for. So just because I'm turning my life around, I want to be a good person, I want to do the right things. Some of that could include paying some penalties for some things that I did. And if a person is really committed to changing, they're going to be okay with paying penance for the things that they did. So that means even though you're trying to turn your life around, and it may be hard because now you've built up some stuff. You build up some stuff, right? And Mr. Little, I want you to go live wherever you want to live. I want you to be successful on this probation. I want you to be. But when you show up and you haven't done anything, that tells me I wanted more for you than you want for yourself. And one thing that I determined for moving forward after I came back to work off of my leave in December, I think I came back December 6th. I said, I got to protect my own peace of mind. And so I cannot want for other people's stuff more than they want for themselves. I'll be on here fighting for the people. Come on, you could do it. You could. Why won't you do it? Oh, I'm not doing that no more. I'm just going to say, okay, you don't want to do it, you go to jail. You don't want to be a better person? Okay, go to jail. You don't want to do. So I think you want to do it, but you have to put the effort into it. Because otherwise, Miss Little, I'm sorry, you're going to have to go to jail at the age of 71, and that'll be bold. That won't be right. Okay?
Yes.
And I don't want you to, because your pastor, he might try to come on here and say, give me a chance and stuff, and then I'm going to hate to not listen to him, because I will. And tell them how many chances I gave you. But we in it together until we're not. We in it together as long as we're together. But when I'm in it by myself, we're no longer in it at all. Okay? So let's see what you can do in 2 months. Let's see if we can get that proof, and then we'll be good. Take them across the hall.
Yes, Your Honor.
All right.
I have one question. Would I turn in my certificate of completion from drug program from Sheriff's and Sobriety House?
Right, you got to get on you got to give them to your probation officer. That's why you're supposed to report to probation on a monthly basis.
Okay.
Okay, so you got to give them to Miss O'Driscoll, and so you're gonna go over there if she's able to see you today. But if not, it's a couple of things. Oh, because let me say this to you. In the report, and Miss Stevenson, she'll make sure that we get this. Miss O'Driscoll listed 2 addresses that they have sent letters to, and she said they did not get any response. You need to make sure probation has your current address and current phone number. So you and your lawyer, you're going to make sure that my clerk and the probation department has your current address and your current phone number. Okay?
Yes.
All right. So, and then you'll give all that information to Miss O'Driscoll, the probation officer, and then she'll send me another report. She sent me a report every time you on the docket. I get a report as to how you're doing. Okay.
All right. Thank you, Your Honor.
All right. You're welcome, Mr. Little. Don't let me mess up your day. You have an amazing day. You have a fantastic day. You have a fabulous day. Don't let me mess up your day. You still have a great day today. Okay.
Yes.
All right. All right.